From the Legal Aid Society of Hawaii, Kona office. I'm here to talk to you today about family law in the Third Circuit. Fortunately, or unfortunately, depending on how you look at it, a lot of self-help users do come to discuss family law issues. The different categories that they come to receive help with include custody, divorce, restraining orders, guardianships, and adoptions. I'm going to be talking about all of those issues today, but I do want to refer you to the training materials that you should have received already and should have in front of you. I'm going to be going through the substantive family law section of your material so you can follow along. I also want to let you know that Legal Aid does have a brochure on nearly every family law topic, and those are available at the self-help centers themselves or online. I also want to let you know that most of the family law court forms are available online on the judiciary website. So you can refer self-help users to the legal aid brochures, to the court forms, or you can use the substantive materials in your packet and available at the self-help center if you should need help. So I'm going to dive right in. We're going to start with divorce. Divorce is covered by Hawaii Revised Statutes 571 and 580. Hawaii is a no-fault divorce state, which means that one party has to say the marriage is irretrievably broken. You do not have to prove that one party or another did something in order to get the divorce. To get divorced in Hawaii, one of the parties must have lived in Hawaii for at least 6 months prior to the filing of the complaint, and within the circuit for at least 3 months. The issues that need to be decided in a divorce include custody, child support, visitation, property division, debt division, spousal support if there is any, and spousal name change. First, we're going to start with child custody. There are two parts of custody. There's legal custody and physical custody. Legal custody is who makes the major decisions for the child. Those would be school enrollment and disenrollment, religious choices, driver's license, some college applications, anything where you would need a legal parent to sign for the child. And then there's physical custody, which is where the child lives most of the time. For each of those categories, you can have sole or joint custody, and they don't have to be the same, meaning you could have joint legal custody and sole physical custody. The child support is actually decided by the physical custody portion, so it's decided by the amount of time spent with each parent. You can tell self-help users that child support is not something that the custodial parent invents out of thin air. It is a state formula, which I believe is somewhat based on a federal formula or other states' formulas. And basically you plug in both parents' income, you plug in any child care costs and any medical care costs, and then the formula brings up a number for support. That number is going to be different if there's joint physical custody or if there's extensive visitation. Visitation generally falls into 3 categories. Reasonable visitation, that's kind of a loose and vague definition that the parties agree on amongst themselves. Then there's supervised visitation. That would be in situations where there was danger to the child, for example, in a domestic violence relationship, or if one parent has substance abuse issues. And then no visitation, which is very rare. It can be awarded, but we don't see that very often. We do hear parents asking for that fairly often, and it's good to remind patrons that that is very rare. All couples who have children who are going through divorce in Hawaii must go to a Children's First class, It's a class where you bring children of the marriage between the ages of, I believe, 6 and 18. The children would go into one room with the other children, and they would be taught about the court process. They would be told what goes on in the divorce. They would talk about parents and sometimes how they get along, sometimes how they don't. It's a good time for kids to be able to talk with other kids and feel like they're not alone in the process. They also divide the wives and then the husbands into a separate group, so there are 3 separate groups, and they talk to volunteers at the Kids First program, talk to each of the groups about the divorce process and how to protect children from it. The main thing being that you do not want to talk to children about anything that doesn't require them to know. So for example, you don't want to say bad things about the other parent. The class is usually enjoyed by the people who go, and it's required in order to get your divorce, so you can just let them know that it's a requirement. Spousal support or alimony is decided by the family court based on a number of factors, the most important of which are the length of the marriage, the standard of living during the marriage, the relative financial situation of each party after the marriage, and one spouse's relative work history, education, and other abilities that would prevent them from supporting themselves. But I can tell you that the most important factor that the court is going to look at probably is the ability to pay. So obviously if no matter how bad off the divorcing parent, the person seeking the spousal support is, if the other person cannot pay, it's not awarded. So that seems fairly obvious, but it's something that we often need to point out to people, that the court is going to be looking at ability to pay as well as the other factors. Name change. A spouse can return to a former married name or a maiden name after the divorce. And then all the forms, as I mentioned, are available on the Judiciary website. You can refer Self-Help Center patrons to those forms. There is also an A2J, or Access to Justice, laptop at the Self-Help desk that a person who just wants to do the forms can use that laptop, and it will walk them through the process. The overview of the process for divorce, which many people would like to have some idea of, is as follows. The plaintiff will fill out the initial packet of forms. They'll file it to initiate their divorce. They will serve the other party with those filed documents, and the other party will have 20 days to respond, to file an answer. If the parties cannot agree on a resolution of all issues, they will be referred to mediation. The court is required to refer people to mediation whenever there is child custody at issue. The one exception to that is if there's domestic violence. A spouse who has been the victim of domestic violence is not required to mediate with the perpetrator of domestic violence for obvious reasons. If the parties cannot agree and they go through mediation and they still cannot agree, the case would be set for trial. And then after evidentiary hearing, a judge would issue a decree based on actually addressing all of the issues that I discussed at the beginning. Another way that divorces sometimes go is by default. So if the responding party fails to file an answer and more than 20 days elapse after service, then the filing party can file a motion to default the other party. And after a brief hearing, if the other person still does not show, the judge will grant the divorce through default as long as the plaintiff can show that service was affected. Service is affected as in any other civil case. It has to be the complaint and summons, and then whatever other documents have been prepared, the filed certified copies, must be served on the other party personally if the other party lives within the circuit, or the complainant or petitioner plaintiff can file a motion for service by mail if the respondent lives on another island or in another state. The motion for service by mail is a very simple form, and it's available on the judiciary website as well. There are also situations where annulment is the way to go, but it's a very specific set of circumstances, and it does not occur very often. The circumstances would be if, and they're available in HRS 580-21 to 580-29. The circumstances would be when the parties were related to each other, where one party was not of legal age, where either party is still married to a living spouse, where either party lacked the mental capacity to consent to the marriage, where the marriage was obtained by force, duress, or fraud, and there was no subsequent cohabitation. So that's important. A lot of people, for the most part, I would say, the people who claim they want an annulment is on the basis of fraud, but they can't have been shown to have cohabitated after the fraud was discovered. And so that usually sends a lot of people the divorce route instead of the annulment route. In a divorce action, if the complainant or the respondent needs immediate orders, because divorces can take a long time, contested divorces can take a year plus. If the complainant needs immediate help, maybe child support, maybe custody, maybe a financial restraining order, there are pre-decree relief motions. Those are available online. I believe only the First Circuit has those, but Third Circuit, like all the other circuits, has a no bounce rule, and so a person needing that relief could take a First Circuit form for pre-decree relief or temporary relief and change the form to say Third Circuit. The things you can ask for, like I said, in pre-decree relief would be anything that you would need decided at the moment. So custody, child support, visitation, financial restraining order. There's even a domestic abuse restraining order. And there's several others. It's a very extensive form with boxes to check, so it can be a really helpful guide for somebody who's going through a divorce and needs immediate relief. There's also a post-decree form, which would be for after the divorce. If one party, for example, is trying to change the orders from the divorce, or if they need to enforce the orders. So if, for example, if the house is not being sold and it was ordered to be sold, or the other party's not paying child support, something like that, there's a motion for post-decree relief that can be used also to change custody or visitation or child support. And again, that form is available online, but I believe it's only, I think, in First Circuit. So they'd have to use that form and change it. There are instructions on the judiciary website as well for all the forms and for kind of pro se divorces in general, so you can refer customers to that. I'm going to move on to paternity. That's HRS Y Revised Statute Chapter 584. Paternity would be to establish the father of a child who was born out of wedlock. If the child was born after July 1st, 1999, and the father's name is on the birth certificate, that's considered a voluntary establishment of paternity. And the father is presumed, the person listed on the birth certificate is presumed to be the father. So, you would use a motion for, or a petition for custody, visitation, and child support, but you would not need to establish paternity if the VEP was completed. I would say the vast majority of people we see do have a father's name on the birth certificate, because now it's so easy to establish paternity at the hospital or directly afterwards that just happens pretty frequently. If no paternity has been established, there is a petition for paternity. Those petitions, I believe, are not available for Third Circuit, but I think that they are for Second Circuit. So the self-help customer could use the forms from the judiciary website for family court for Second Circuit. There's also a packet of forms available at the family court and the circuit court clerk's offices. They can pick up the hard copies of the forms. Just like in any other case, family court forms have to be original plus 3 copies. There is a filing fee for divorce as well, but if the person is low income, they can fill out a request for a waiver of the filing fee, and that's granted generally if parties are below 150% of federal poverty. There should be an income guidelines list at the self-help desk that shows if the person would meet that criteria. The nice thing about that is it also shows you whether they might qualify for legal aid, and so you could direct the self-help desk patron to legal aid to try to get some additional help with their family law case. Returning to the paternity action, the following parties can seek to establish paternity: the natural mother of the child, any man who believes he's the natural father of the child, any presumed father of the child. So a presumed father would be a person who was married to the woman at the time she gave birth, and also somebody who's on the birth certificate. Another good referral to make in a paternity situation is to the Child Support Enforcement Agency, or CSEA. CSEA will help a person to establish paternity and also to seek a child support order. And CSEA will help with setting up the DNA test if that's required, setting up the hearings, preparing the orders. They do not represent either side, but this is a good referral to make to somebody seeking to establish paternity who's maybe low income and maybe doesn't qualify for legal aid because there's a conflict, something like that. They can be referred to CSEA to have paternity established, and also at the same time they would get custody and visitation orders. The custody is the same as it was in the divorce. It would be legal custody, physical custody, and then visitation and child support. The forms, like I said, are only for Second Circuit, but Third Circuit residents can use them. Just make sure they change the upper left-hand corner to say Third Circuit rather than Second Circuit. And again, service is the same. It has to be personal service if the other party lives on the island. In these cases, paternity cases, there could be more than one respondent. Sometimes there are 3, so there could be, for example, mother versus presumed legal father, presumed biological father, and CSEA. That has happened. So you do want to direct the self-help patron to notice CSEA if the child has been on state assistance, for example, TANF, welfare, state medical. They're going to want to perhaps recoup those costs from any father whose paternity is then established. Another issue that a self-help desk patron might be asking about is guardianship of minors. That's governed by statutes 560:5-201 to 560:5-210. Guardianship of a minor allows someone who's not the parent of a child to legally care for that child until the child turns 18. The guardian would make decisions as if they were the legal parent, but the parent's rights are not terminated. So they would still, for example, be required to pay child support if the guardian was on public benefits, or the guardian sought child support through the CSEA. The court uses the same standard for awarding guardianships as they do in any other case involving children, which is the best interest of the child. That's available, I believe, in Section 586. That's a nice list to be able to print out for patrons who have issues regarding custody or best interests of the child for a guardianship or for adoption, something like that. It's kind of It's kind of a vague standard, but there are a lot of criteria listed there. For example, the mental and physical capacity of the parents, any history of abuse, history of caregiving, any needs of the children, parents' ability to cooperate with the other parent, things like that. So to somebody who is wanting to know how the family court will decide about their children, may be directed to that statute. Court action is required to get a guardianship. It's also required to terminate one. Once granted, the guardianship will last until the child turns 18 unless it's terminated earlier. The court will appoint a guardian when it's in the best interest of the child and when either the parents consent or parental rights have been terminated or parents are unwilling or unable to exercise their parental rights. The Third Circuit does not have forms online for guardianships. The First Circuit does have a packet of forms and they can be modified. Legal Aid has brochures on guardianship. There's also a pro se packet, an instruction packet for First Circuit that might be helpful to Third Circuit patrons as well. If the self-help desk customer or patron is not sure whether they want a guardianship, an adoption, or a power of attorney, Legal Aid has brochures on which would be most appropriate. A power of attorney is good for 1 year, and it allows somebody to make decisions, for example, to enroll a child in school. This would be a special power of attorney, to enroll the child in school, to consent to medical care, to accept public benefits for the child. So that would be a sort of a temporary thing. The problem with those is that they're revocable at any time. So if a parent, for example, has a drug problem or is otherwise unsafe, a power of attorney may not be strong enough because that parent may be able to just tear it up at any time. And so, for example, that wouldn't be a strong enough support for that child. So perhaps a guardianship would be sought. Adoptions are different from guardianships because they terminate the parental rights. So those would be cases in which they no longer want, the prospective adoptive parent no longer wants the other parents to have any parental rights whatsoever. The child becomes as if they were born to the adoptive parents, and they actually get a new birth certificate as if the child was born to them. A single person or a married couple may adopt, but not an unmarried couple as of yet. The action would have to notify any legal parents, any guardian of the child, and the Department of Human Services must be notified. A child who's 10 years or older must consent to their own adoption. And I forgot to mention that in a guardianship, if the child is 14 or older, the child must consent to their guardianship. In an adoption, if no father's name is on the birth certificate and his identity is unknown or his whereabouts are unknown, the court can be satisfied with a due and diligent search for the father, trying to locate one or more parents. The court may require notice to be published in a newspaper of national circulation. It can be done through the Honolulu Star Advertiser for about $400 to $500. So it is an expensive. I'm sorry. Actually, this says $1,500. The Maui News charges between $400 and $500. If a parent's rights have been terminated, their consent is not required. There is no form packet available in Third Circuit on the website, but patrons can use the First Circuit forms and modify them. Temporary restraining orders, those are governed by HRS Chapter 586. A temporary restraining order is an order that tells a person they cannot contact, harass, bother, or come within a certain amount of space of another person. Those are done in family court if the filing party has related to the other party, so sister, brother, mother, father, grandmother, etc. If they have lived with the person in the past, or if they have a child together, or any other dating or romantic relationship. If none of those criteria exist, and you want, the patron wants an injunction against the other person, they'd have to file in district court. And that's a district court injunction against harassment. If one of these situations, these familial or romantic situations do exist, then it would be a family court restraining order. That case is started by an ex parte motion for temporary restraining order. And you can refer self-help desk patrons to Alternatives to Violence, or ATV. They have advocates there who will help people fill out the forms to get a restraining order. That temporary restraining order, if granted by the judge, is good for 90 days. Now, the judge just uses a very low standard for signing those temporary restraining orders. He has to assume that what's written in the ex parte petition is true, and if so, it would be domestic abuse. And so that's why there's a hearing pretty soon after those temporary restraining orders are issued, so that if the other party needs to contest those matters, then they're able to do so. There's no filing fee for TROs in family court. They are effective as soon as the judge signs it, but they're only enforceable when the other party is served with it. Now, unlike other family court cases, temporary restraining orders are served by the police department. So the victim is not required to serve their own perpetrator with that. The court in Kona or Waimea will set an order to show cause hearing, and both parties will have the opportunity to argue whether or not the court should continue, whether an order for protection is necessary. There is the order to show cause hearing. Kona and Waimea are a little bit different from, I believe, First Circuit, where the evidentiary hearing is held on the first return date. In the Third Circuit, there's a return on the petition, where the petitioner has the chance to say, yes, I still want to go forward, and I do want a protective order. And then the respondent has the chance to say, either I admit, I deny, or I want to invoke my right to remain silent. If there's an admission or an invocation of right to remain silent, the judge can go ahead and issue the order for protection based on the petition. If the respondent denies the allegations, then the court will set an evidentiary hearing, and typically those are approximately 1 hour in length, and each party would have a chance to bring witnesses. They are bound by what was written in the petition, so you could encourage a self-help desk patron to make sure that their petition includes every instance that they can think of or that they might want to bring up in an evidentiary hearing. Again, there are forms online, but I would recommend referring self-help desk patrons to Alternatives to Violence, because they do have trained advocates there to help people fill out those forms. And that covers family law in the Third Circuit. Thank you.